All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour.
The Presiding Judge. Good afternoon. I would like to welcome everyone present today in the courtroom and in the public gallery. Court officer, please call the case. Court officer, thank you, Mr. President, Your Honors. Situation in Mali, the prosecutor versus Al Hassan Ak Abdul Aziz Ak Mohammed Ak Mahmoud, ICC 01120118, and we are in open session. Presiding Judge, thank you. On behalf of my colleagues, Madame Judge Reine Adelaide Sophie Alpini Gansu, and Judge Macperen de Brechambeau, I would like to welcome all the parties and participants, as well as the suspect, Mr. Al Hassan. I would like to call on the parties and participants to introduce themselves. I will begin with the prosecutor. Madame Bensouda, please.
Honorable judges, the Office of the Prosecutor is represented today by Gilles Dutertre, Senior Trial Lawyer, Jaganaden Munisami, Trial Lawyer, Hesham Murad, Trial Lawyer, Diane Looping, Trial Lawyer, Raymond Sandoval, Trial Lawyer, Marie-Claudine Umurungi, Assistant Legal Officer, Sarah Kokio, Assistant Legal Officer, and Sanya Bakulesh, Case Manager, and myself, Fatou Bensouda, Prosecutor.
Merci beaucoup.
Judge Covers. Thank you very much, Madam Prosecutor. I will now address the defense. Ms. Taylor, please introduce your team.
Good afternoon, Mr. President, Your Honours, and good afternoon to all my colleagues in the courtroom. My name is Melinda Taylor. I am appearing this afternoon on behalf of Mr. Al Hassan, together with my colleagues, Madam Marie-Hélène Proulx, Madam Sarah Marinier Doucet, Mr. Mohamed Youssef, Ms. Dolly Chala, Ms. Marie-Noël Delille, and Ms. Lily Wang. Thank you very much.
Judge Kovacs, thank you. The legal representatives of victims, can you introduce yourselves, please? Mr. President, Your Honors, good afternoon. The legal representation team this afternoon is made up of Maître Mayombo Kasongo, myself, Maître Seydou Doumbia, and we have with us Ms. Claire Laplace, as well as Ms. Prisk Biyeke Dipanga. Mr. President, we were supposed to be with Maître Fidel Sita Luvengika, but who unfortunately cannot be present because of health problems, and he sends his regards. Judge Kovacs, thank you. Now I will present my colleagues, the judges of Pretrial Chamber 1. To my right is Judge Perrin de Brechambeau, and to my left is Judge Reine Adelaide Sophie Alapini Gansu. And lastly, I am Peter Kovacs, presiding judge of this chamber. I would like to make some clarifications. I would begin by telling you about the nature of this hearing as well as the role that the pretrial chamber has to play. We are at the pretrial stage of the case, and this chamber has no objective. It does not have as objective to decide on the guilt or innocence of Mr. Al-Hassan. Our duty is merely to determine whether there is sufficient evidence to establish substantial grounds to believe that Mr. Hassan committed the crimes charged against him as set out in Article 61(7) of the Rome Statute. The Chamber would like to reiterate the principles that should guide the hearing. Firstly, the presumption of innocence in accordance with Article 66 of the Rome Statute. Secondly, the burden of proof lies on the prosecutor. Accordingly, the prosecutor should provide evidence to prove the charges presented against Mr. Al-Hassan in accordance with the evidentiary standard stipulated in Article 61(7) of the statute. Thirdly, the defense shall enjoy all the rights guaranteed by Articles 61(6) and 67 of the statute. Lastly, even though the general rule is that the hearing shall be public, it is possible, in order to protect confidential information, particularly with regard to witnesses, that we are compelled to go into private or closed sessions. According to the scheduling order, the prosecutor shall have 6 sessions of 1 hour 30 minutes each to make her oral submissions. The legal representatives for victims will have 1.5 hours, and the defense will have 6 sessions. The time allocated includes the times for questions which were distributed before the hearing. The parties and participants shall then have 30 minutes each to present their closing statements. As indicated in the amended order scheduling the confirmation of charges hearing, these statements shall be made or shall take place on the 17th of July 2019. I would like to add that if one or the other of the parties or participants does not fully utilize the time allocated to them, another presentation may be moved forward even if it had not been scheduled for the ongoing session in question. This means that the parties and participants must be ready at all times and willing to be flexible. I would also like to recall certain aspects which are technical for the good conduct of the hearing. When parties and participants refer to items of evidence, they have to indicate the level of confidentiality of such items of evidence and specify whether it is necessary to go into private or closed session. The Chamber would like to recall to the parties and participants that during public audiences, or rather public hearings, they should not use the names of the victims or witnesses, but only use the pseudonyms. Lastly, I would like to remind the parties and participants to refrain from speaking too fast. More specifically, I urge the parties and participants to observe a 5-second pause after each sentence, because we have simultaneous interpretation and including into Arabic. In keeping with Rule 122 of the Rules of Procedure and Evidence, I have the duty to request that the charges be read. Now, I address Mr. Hassan. Would you want the charges to be read out to you, or do you have a very clear understanding of the charges also already?
I know the charges, sir.
Merci beaucoup.
Judge Covers, thank you very much.
Ceci dit, Monsieur Alassane, j'espère sincèrement.
That said, Mr. Al-Hassan, I sincerely hope that you have understood the nature of the charges against you by the prosecutor.
نعم فهمت.
Yes, I have understood them.
Je vous en remercie.
Thank you very much. The Chamber will state that pursuant to Rule 1223 of the Rules of Procedure and Evidence, the parties have the possibility to, I quote, raise objections or make observations concerning an issue related to the proper conduct of the proceedings prior to the confirmation hearing. The Chamber would also like to remind the parties that pursuant to Rule 1224 of the Rules of Procedure and Evidence, the objections and the observations raised in application of Rule 1223 of the Rules of Procedure and Evidence may not be presented later in the confirmation or trial proceedings again. Now, I would like to address myself to the parties, and they should tell us whether they have the intention of raising objections or making observations pursuant to Rule 1223 of the Rules of Procedure and Evidence. Madam Prosecutor, you have the floor.
None, Mr. President.
Merci beaucoup.
Judge Kovacs, thank you very much, Madam Prosecutor. Now, I would like to ask the defense whether they intend to raise any objections or present observations pursuant to Rule 1223 of the Rules of Procedure and Evidence. Madam Taylor, you have the floor.
We do have the intention of raising 3 issues, and I will be guided by the Chamber as to whether we should raise them now or a later point today.
Mettez-leur maintenant.
Judge Kovacs, Ms. Taylor, now, so you have the floor.
Thank you, Mr. President, Your Honours. I will be addressing 3 issues, and my colleague, Maitre Poul, will be addressing 1 small issue at the end of my submissions. Mr. President, Your Honours, as stated by Robert H. Jackson, the world yields no respect to courts that are merely organised to convict. And I would suggest that it is equally true that the world yields no respect to legal proceedings which are organised for a predetermined purpose. For example, to confirm the charges against a particular defendant. For this reason, the objective of the confirmation process, which is to filter out evidentially and legally unsound cases, must be given full effect. As explained by Judge Cole in his dissenting opinion in the Ruto confirmation decision, the confirmation of charges can have enormous negative consequences for the charged person, including unnecessary public stigmatization. For the court itself, it can lead to huge expenses and amount to a violation of the necessity to ensure as much as possible judicial economy in the interest of justice. The defense nonetheless has 3 reasons to fear that the filtering purpose of the confirmation proceedings will not be applied effectively in this case. And those 3 reasons are, firstly, the lack of effective judicial supervision as concerns the prosecution's investigations and disclosure in this case. Secondly, the organisation of this confirmation process itself, particularly in light of the 43 questions sent to the parties on Friday evening. And thirdly, the composition of the pre-trial chamber, in particularly as concerns the ongoing involvement of Judge Alapini Gansu. As concerns our first ground, to harken back to Judge Call in the same Ruto decision, he discussed the importance of impartial and expeditious investigations during the pre-confirmation phase. Specifically, Judge Call argued that in order to comply with the spirit and objective of both Article 54(1) of the statute and the rights of the defendant set out in Article 67, it's necessary for the prosecution's investigations to cover all factors that might be relevant to the judge's ultimate determination in this case. And that necessarily encompasses both incriminating and exonerating circumstances. And in circumstances where that has not occurred, where there has been a piecemeal or guilt-focused investigation, then according to Judge Call, confirming the charges would be risky, if not irresponsible. If, after the confirmation of charges, it turns out that it would be impossible to gather further evidence to attain the decisive threshold of beyond reasonable doubt, then the case in question may become very difficult or may eventually collapse at trial, with many serious consequences, including for the entire court and the victims who have placed great hopes in this institution. Judge Call's words of caution proved to be extremely prescient as concerns the Kenya cases, which eventually collapsed at trial. And regrettably, the defence would submit that they are equally applicable to the current case. And that is that the prosecutor has conducted its investigations into the events in Timbuktu with its eyes wide shut. And as a result, even if they managed to nudge the case over the line at this particular phase of the case, there is a significant risk that it will collapse at trial due to the unreliable nature of the evidence relied upon. Now, during the substantive part of these hearings, my co-counsel, Ms. Prue, will explain to the bench what you will not hear during these hearings, and that is the absent context concerning crimes committed by the Malian authorities against the Tuaregs, and the desperate situation for the Tuaregs in the north that both preceded and accompanied the events set out in the charges. But for the purposes of today's hearing, I intend to focus specifically on the prosecutor's failure to investigate and disclose exculpatory information under Article 67(2) of the statute. This article is framed broadly to cover information that exculpates the accused or mitigates guilt, but also any evidence that undermines the credibility of prosecution evidence. And that latter category is extremely broad and can cover incentives given to witnesses, criminal convictions, links and contacts between witnesses, or any information that might affect the reliability of evidence. The prosecution commenced its investigations in 2013 and clearly started to target Mr. Hassan in 2017. But over this entire time period, they claim to have identified only 20 items of exculpatory evidence. That means that out of the 20,104 items disclosed in total, the prosecution considers only 20 items demonstrate Mr. Hassan's innocence, mitigate his guilt, or undermine the credibility and reliability of prosecution evidence. There is therefore an appearance that in order to avoid judicial oversight concerning the consequences of non-disclosure, the bulk rule seems to have been replaced by the zero rule, and nothing is considered to be exculpatory. But at the very least, for this particular category as concerns information that undermines or affects the credibility of the prosecution's case, we know that there was exculpatory evidence under the prosecution's very eyes they chose to look away from. And this is amply demonstrated by the record of interviews with Mr. Hassan. And it should be obvious from the public version of the prosecution's document containing the charges, DCC, that the prosecution's case relies heavily on alleged concessions and information provided by Mr. Hassan himself. It starts, for example, at paragraphs 116, 209, 237, and onwards. And in fact, the prosecution relies on his statement in 507 footnotes in the DCC. And for 224 of these footnotes, his statements are the only evidence relied upon to support the allegation in question. So any information concerning the admissibility, the reliability of these statements would clearly fall under Article 67(2) of the statute. And we know that such evidence exists and that it was ignored by the prosecution because Mr. Hassan himself brought it to the prosecution's attention during his very first interview. Specifically, at the time that he was interviewed, he was detained in a location notorious for human rights abuses. Indeed, it was so notorious that in the transcript of later interviews, we can read the persons present describing it as being like Guantanamo Bay, to which the prosecutor investigator replies that in Europe it is the same. They demand the Africans to detain the terrorists, and often, yes, it's exactly like that. MLI OTP 0069-1795 at 1797. But in any case, the prosecution didn't need to Google human rights abuses to know that there was a problem, because on the very first day of his interviews, Mr. Hassan told his interviewers that he had been tortured, that he had been threatened with death if he did not adhere to a particular story. Now, given that the ICC prosecutor has an explicit mandate to investigate acts of torture and arbitrary detention, one would have expected the prosecution to explore these allegations in a thorough manner, with a view to identifying crimes under her mandate. But instead, the prosecutor investigators merely changed the topic and continued to interrogate Mr. Hassan about the events in 2012, even though it should have been blatantly clear to any trained investigator that the evidence obtained in such an environment has no evidential value. It would also seem that they decided this location was fertile grounds for potential witnesses who were clearly desperate and vulnerable, and they therefore interviewed other individuals detained in the same location. In sum, even though Article 54(1) obliges the prosecutor to conduct her investigations in a manner that is fully consistent with the rights of suspects, it would appear that in this case, they turned a blind eye to allegations of torture, simply because the victim was a suspect. And the situation did not change after Mr. Hassan was arrested and brought to the ICC. At the very first opportunity, his initial appearance, Mr. Al-Hassan instructed his lawyer to inform the chamber that he'd been mistreated during his arrest and detention in Mali. But this complaint fell on deaf ears. Rather than independently investigating the circumstances of Mr. Al-Hassan's detention and treatment, the prosecution merely offered to interview Mr. Al-Hassan again. Hardly a remedy for someone who's already been interviewed by them 19 times. The prosecution then also used his statements to justify the imposition of extremely oppressive detention conditions, which we are not allowed to discuss in public. The prosecution has also impeded defense efforts to investigate these matters in an independent manner. They've denied requests for disclosure as concerns information that is clearly relevant to the admissibility of his statement, or at best, handed out information in a piecemeal and tardy fashion. And this lack of disclosure has been exacerbated by a lack of vigorous judicial oversight. Rule 121, Subsection 2, obliges the pretrial chamber to issue decisions on disclosure with a view to ensuring that the prosecution complies with its obligations. Subparagraph B further requires the chamber to convene status conferences with a view to overseeing the disclosure process. The chamber nonetheless declined to issue any such rulings or to convene any status conferences, and as a result, there are still requests for disclosure that are pending before the chamber, even though the confirmation proceedings are starting today. The chamber also disregarded a defense request to convene a status conference to discuss the impact of delays in the proceedings in light of Mr. Al-Hassan's conditions of detention. And that request was filed on the 14th of March, 2019. And this lack of judicial rulings is problematic for two reasons. Firstly, it creates a sense of impunity for the prosecution. They are now aware that they will face no consequences if they do not comply with their disclosure obligations. And this is reflected by their failure to respond to and comply with our disclosure requests. It's also reflected in the repeated manner in which the prosecution has disregarded judicial rulings and deadlines concerning the filing of the charges in this case. And I refer to the exchanges set out in Annex 3 of our Table of Authorities. And secondly, the lack of rulings has delayed defense investigations in preparation. Our applications concerned information that was necessary to conduct further investigations and inquiries. The absence of a ruling means that we are still at a very preliminary stage concerning our investigations and preparations. This results in a very imbalanced process. On the one hand, the prosecution has had a significant amount of time and opportunities to advance its case. But on the other, the defense has barely left the starting block. And if the charges are confirmed, this will continue to have significant implications as concerns the defendant's right to speedy trial proceedings, since fundamental defence preparation has now been shifted to the trial phase. And this brings me to my second point regarding the organisation of the confirmation process itself. It took the pre-trial chamber 6 working days to determine that the threshold for issuing an arrest warrant was met in this case. But the confirmation process has now lasted for over 15 months. And that is an extraordinarily long time to maintain an uncharged person in detention. The prosecution was also authorised to file a 500-page document containing the charges, which is an extraordinarily long and complicated document to frame the parameters of responsibility in this case. The single judge justified the decision to grant the latter request on the basis that the production of one document would produce greater clarity and provide a clear and exhaustive frame of reference for the specific evidential citations and allegations that will be relevant to the charges and to this hearing. And in setting out the calendar for the hearing, the single judge further emphasised that the oral submissions during the hearing should not constitute a new source of information or argument, but should be a succinct summary of the existing submissions set out in that 500-page document. This clarity, this clear framework has now been jettisoned by virtue of the Chamber's decision to request the prosecution to respond to a list of 43 separate questions communicated last Friday evening. The questions do not concern just legal or procedural issues. Rather, in many cases, it would appear that the Chamber is inviting the prosecutor to expand the scope of its charges and to raise new evidential arguments at the hearing, evidential arguments that will not have been disclosed in advance of the hearing. And the very first questions are emblematic of this approach. For example, the current version of the DCC very clearly states that the civilian administration in Timbuktu chose to leave before the arrival of Ansar Dine. That's paragraph 107. The defence relied on this assertion of fact in preparing for this hearing. But in question 1, the pre-trial chamber has now invited the prosecution to change its case, to plead instead that the civilian administration were forced to escape, or that they were fired or otherwise driven out. And on issues of sexual violence, the pre-trial chamber has invited the prosecution to supplement its material facts with additional allegations from the legal representative for victims. And this has the effect of transforming the confirmation hearing into a mini-trial, but without any of the protections of a trial, or indeed, any of the protections that should apply to the confirmation hearing itself. And in this regard, Article 61 and Rule 121 of the rules set out 2 key safeguards which the defence submits have not been respected in this case. Firstly, Rule 121 requires the prosecution to file its charging document at least 30 days before the hearing. If the prosecution wishes to amend the hearing, it can do so no later than 15 days before the hearing. Rule 121, subsection 8, then prohibits the pretrial chamber from taking into account any charges or evidence presented after those deadlines. But as a result of these new questions and issues, the defence is entering this hearing without any clear idea as to what charges might be put in place or the nature, cause, and content of these charges. A further concern arises from the fact that the Chamber's inquiries appear in several cases to have arisen from the observations of the legal representatives for the victims, which were filed last Thursday. Now, the Chamber's reliance on these observations is highly problematic for several reasons, the two key problems being the following. The first key issue concerns the nature of these observations, and that is that they cite the highly prejudicial factual articles that were never disclosed and tendered in this case. The decision on victim participation gives the victims in this case no right to tender evidence, nor should they be given this right at this phase of the proceedings. And at this point in time, the defence has received absolutely no information concerning the persons granted victim status. We haven't even received a redacted version of their application form. They are, to all intents and purposes, faceless prosecutors, untrammelled by the duties and obligations of the prosecution. And this lack of prosecutorial obligations and duties is demonstrated by the fact that their filing publicly refers to Mr. Hassan as an accused person at paragraph 50, implying that the charges have already been confirmed. Their allegations therefore constitute a highly unreliable and prejudicial foundation for inviting the prosecution to expand the scope of its charges in this case. The pretrial chamber's reliance on such allegations also contravenes the appeals chamber's ruling that victim participation should take place within the existing scope of the charges, as framed by the prosecution. And that's decision in the Labunga case 1432 at paragraphs 62 to 65. Now, the second grounds for concern regarding the pretrial chamber's reliance on the victim's observations arises from Judge Alapini Gansu's prior involvement in the Malian Fact-Finding Commission. Specifically, the defence has grounds to believe that Judge Alapini Gansu may have interacted with participating victims and victim intermediaries in this case, and further advised and assisted them in their connection with the formulation of a domestic criminal complaint concerning sexual violence that was filed against Mr. Hassan. Now, the right to an independent and impartial tribunal is a linchpin for justice. To be listened to know that the bench will dispassionately consider and weigh up the arguments presented to them, and then issue a decision based solely on the matters put before them. This right is of the utmost importance to an individual who faces the weight of public opinion and the public forces of the prosecution. For these reasons, Article 41, Subsection 2, places a strong obligation on judges to raise any issues that might impact on their ability to judge a particular case in an impartial manner. And this duty is of fundamental importance to the fairness of proceedings because the parties will not always be well placed to identify potential conflicts. The defence is particularly handicapped as we do not have access to the names of victims and witnesses and intermediaries. And we cannot part the curtain of investigative secrecy to know exactly how the investigations in this case unfolded and who was involved. In line with this obligation, judges routinely bring to the attention of the presidency any issues that could potentially impact on the appearance of a fair and impartial trial. For example, in the Bashir case, Judge Monaghan, proprio motu, raised her previous involvement in the African Commission of Human Rights in the adoption of a resolution concerning the situation in Sudan. And she raised the extent to which it could create an appearance of partiality as concerns her role as a pretrial judge in the Bashir case. The presidency rejected her request to recuse herself on the grounds that, firstly, the fact-finding mission did not make findings concerning allegations of genocide, and secondly, Judge Monaghan had not been personally involved in the fact-finding mission. She merely approved a resolution concerning the need for investigations. Now, the Al-Hassan defense has quite clearly indicated that it considers these issues to be of fundamental importance to Mr. Al-Hassan's fair trial rights. We would have expected any judge in a similar situation to Judge Monaghan to raise these issues to protect the integrity of the proceedings. But that didn't happen. And as a result, the defense has been compelled to dedicate its limited time and resources looking into issues that should have been raised proprio motu in an upfront and transparent manner. And after conducting a very cursory search of these issues, we have identified matters of extreme concern. And the basis for our concern is the following. In 2013, Judge Alapini Gansu was appointed by the African Commission on Human and People's Rights to conduct a fact-finding mission in Mali in relation to the events in 2012. And the document setting out that mandate is number 1 in our table of authorities. The first mission was conducted in June 2013. Judge Alapini Gansu personally directed the mission and the drafting of the report and met with various persons who might be witnesses or participating victims in this case. At a press conference on 7th of June 2013, which took place at the same time as the mission, the delegation informed the Malian public that the goal of the mission was to prove the guilt of the perpetrators of human rights violations and then bring them in front of national courts, or where appropriate, subnational and international courts. And that's set out in the Amnesty International report, which is number 2 of our table of authorities. The mission report, which is number 3 on our list, was issued during the 53rd session of the African Commission on Human and People's Rights. And that report made specific findings concerning alleged crimes committed by Ansar Dine, pursuant to the implementation of Sharia law in Timbuktu. For example, paragraph 53 makes the following finding. Still, with regard to the implementation of Sharia, the delegation learned that terrible acts such as stoning, flogging, and amputation were carried out during the period of occupation. According to information gathered, these acts were carried out by armed Islamic groups, in particular Ansar-Din, Majao, and Akmi, following a system of summary justice which they established. And this language mirrors the prosecution's allegations in this case. At paragraph 90, the report states that considering the length of the period during which the human rights violations were committed and the number of victims, there is no doubt that there were serious and massive human rights violations. No doubt. That doesn't leave much room for debate at this hearing concerning if and whether such violations took place. At paragraph 91, the report states that rape carried out against women and girls during the crisis are crimes against humanity and should be judged by the International Criminal Court in the absence of action by the Malian government. The question as to whether rape was carried out in a systematic or widespread manner pursuant to an organisational policy, that's a live issue in this case and during this hearing. On the 1st to the 3rd of July, the next month, Judge Alipini Gansu was invited by FADH and Malian human rights associations to lead a workshop on documenting human rights violations and to facilitate information sharing between decision makers and human rights activists. And in her report to the African Commission during the 54th session, that's document number 4 on our list of authorities, Judge Alipini Gansu stated that the link between this training component and the ongoing work of documenting human rights violations in Mali by various actors cannot be overemphasized. At paragraph 19 of the same report, Judge Gansu expresses her view that the Commission's experience in the documenting of human rights, through its fact-finding mission in particular, must necessarily be shared. Furthermore, as head of the human rights component of the African Union Mission in Mali and the Sahel, which engages in monitoring and human rights documentation activities in Mali, it was logical for us to share the experience acquired on the ground. I therefore highlighted the importance of documenting violations in the effort to combat impunity. I also indicated that the objective of this documentation should not be limited to the denunciation of acts, but should be extended to planning effective future activities to deal with cases of violations. At a conference held in October 2013, Judge Alipini Gansu informed the press that the findings concerning violations of human rights and humanitarian law committed in the north of Mali were overwhelming, and that this included instances of illegal detention and violations of fair trial proceedings, which again appear to be linked to the allegations in this case. That's document number 5 in our table of authorities. And we would suggest that there is a very fine line between overwhelming and substantial grounds to believe, which is the threshold to be applied at this hearing. From November 2013 to April 2014, Judge Alapini Gansu then acted as head of the human rights component of the African Union mission to Mali. That's MISAHEL. And it would appear that in this capacity, Judge Alapini Gansu continued to document evidence concerning crimes allegedly committed in Timbuktu and to liaise with local activists and authorities involved in domestic investigations. And this included meeting directly with victims. Judge Alapini Gansu also explained in her report to the African Commission that her mandate included providing direct assistance to Malian authorities in relation to transitional justice and reconciliation issues. That's document number 4, paragraphs 7 to 10. At a March 2014 press conference, Mr. Held further explained that Judge Alapini Gansu's role included meeting detainees who had been arrested in connection with alleged crimes committed in the North and interviewing them as concerns those crimes. That's document 6. The 2014 Misahel annual report also stated that Misahel human rights observers actively followed any domestic cases and investigations initiated in connection with alleged crimes committed in 2012. It's document 7. In June 2014, Judge Alapini Gansu further participated in a press conference and a series of workshops in Bamako with human rights lawyers, including FIDH and AMDH. The purpose of this workshop was to discuss collaboration between Judge Alapini Gansu's African Union officers and the NGOs in question. And this is document 8, page 6. Now, these NGOs were ultimately responsible for initiating a domestic criminal complaint against Mr. Hassan for allegations of sexual violence. According to a contemporaneous news article, it's document number 9, the 24th of June 2014 press conference was hosted by FIDH and AMDH. And the purpose of that was to discuss the status and evidential difficulties associated with their complaints concerning allegations of sexual violence, in particular the problem that victims would not come forward. On 30th of July 2014, the Misahel Human Rights Section hosted a conference on information sharing with local NGOs and lawyers. That's document number 10, page 4. During this conference with FIDH and NGOs, Misahel presented its April 2014 fact-finding report, drafted by Judge Gansu, which concerned the documentation of human rights abuses in Mali, including findings concerning crimes allegedly committed by Ansar Dine in Timbuktu. Misahel further advised the participants concerning the instigation of litigation concerning these violations. In November 2014, Judge Alapini Gansu also participated in a cooperation conference hosted by FIDH in Paris. And the purpose was to discuss strategies for bringing perpetrators to account. And that's document 11 and document 8 in our table of authorities. In March 2015, FIDH and AMDH filed a complaint against Mr. Hassan in relation to these allegations of sexual violence. This complaint has been relied upon by the prosecution in this case. It was relied upon at paragraph 290 of its application for the arrest warrant. Now, on the grounds of this procedural history, the defence for Mr. Al-Hassan respectfully submits that there are reasonable grounds to conclude that, firstly, Judge Alapini Gansu was previously involved in the proceedings against Mr. Al-Hassan in an investigative and advisory capacity. And secondly, and in the alternative, this prior involvement has impacted on the appearance of impartiality in this case. As concerns the first ground, according to Article 41, Subsection 2A, this ground is in itself sufficient to contest the continuing involvement of Judge Alapini Gansu in this case. The article is framed broadly and specifies that a judge shall be disqualified from a case in accordance with this paragraph if, inter alia, that judge has previously been involved in any capacity in that case before the court or in a related criminal case at the national level involving the person being investigated or prosecuted. This prohibition would therefore capture Judge Alapini Gansu's prior involvement in collecting evidence concerning alleged crimes committed by members of Ansar Deen during the time period of the charges in this case, and her role in meeting individuals who are likely to be participating victims and witnesses in this case. It would also capture her role in providing information, advice, and assistance to the NGOs that filed a criminal complaint against Mr. Al-Hassan in connection with the allegations overlapping with his case. And finally, it would capture her role in advising national judicial authorities responsible for conducting domestic proceedings against Mr. Al-Hassan. The role played by Judge Alapini Gansu is clearly distinguishable from the circumstances raised by Judge Monaghan, insofar as Judge Alapini Gansu played a direct and personal role in conducting the fact-finding missions and drafting the factual findings concerning alleged crimes committed by Ansar Deen. Judge Alapini Gansu also expressed a particular opinion concerning whether crimes in this case had been established, including as concerns acts of sexual violence as crimes against humanity. Judge Alapini Gansu also described her role as being directed towards establishing the criminal responsibility of individual perpetrators and assisting efforts to bring the perpetrators to justice. Apart from the broad prohibition set out in Article 41, Subsection 2A itself, we also submit that the factual circumstances at play fall foul of the judicial guidelines for impartiality established by the European Court. And I refer in particular to the case of Piersac in Belgium, where the court found that the judge's former involvement in the prosecution services gave rise to an appearance of partiality. And in that case, the role played by the judge within the prosecution division had been to revise submissions, provide legal advice, and discuss the approach adopted in the case in question. And that's paragraph 31 of the European Court's judgment. And that role is clearly analogous to the role played by Judge Alapini Gansu. The second ground concerns the impact on the appearance of partiality of the proceedings stemming from this prior involvement in the case. And the appearance of impartiality is fundamentally undermined by, firstly, Judge Alapini Gansu's prior statements concerning live issues in this case, and secondly, the link between the matters investigated by Judge Alapini Gansu and the questions formulated by the bench for the parties to address during the confirmation hearing. And in terms of statements, there is an appearance that Judge Alapini Gansu has reached firm legal and factual convictions concerning issues in this case. And that includes the nexus elements for crimes against humanity, which is contested by the defense. It includes the link between sexual violence and the implementation of Sharia law, which is contested by the defense. It includes the link between Sharia law, forced marriage, and rape. And here I refer to the particular language employed by Judge Alapini Gansu, that the evidence against Ansar Deen is overwhelming, that crimes against humanity or rape definitely occurred, that these statements leave no room for an appearance of doubt. A reasonable observer, apprised of these statements, would automatically conclude that the confirmation of charges in this case is a foregone conclusion. The defense are merely whispering to the wind. And the particularly emotive reaction that Judge Alapini Gansu had as concerns her interactions with victims of these alleged crimes also gives rise to an appearance that Judge Alapini Gansu is likely to base her decision on the impressions formulated during these interactions. For example, in her 2013 report, Judge Alapini Gansu wrote that the most striking case is that of a 9th year student in Timbuktu whose veil fell off while she was doing laundry. The delegation was informed that the girl was taken to the road injunction where people are disgraced to be flogged. If the encounter in question was striking, then it means that the allegations struck a chord with the delegation, that they created an impression that stayed with the delegation, including potentially to the current day. And here, it is the unidentified nature of the victims and witnesses in this case, combined with the very broad scope of victim participation, which aggravates the prejudice to the defense. And that is that because of the particular system for victim participation adopted by the Chamber, the defense has no way of identifying the specific extent to which Judge Alapini Gansu's interacted with victims and witnesses in this case, and the degree of resultant taint. We do, however, know that P570 and P547, both prosecution witnesses, participated in the FIDH complaint. We also know that Maître Seydou Doumbia, who was appointed to represent victims in this case, was one of the lawyers who submitted the complaint to domestic courts. And in his public observations concerning the charges last Thursday, Maître Doumbia raised exactly the same concerns expressed by Judge Alapini Gansu in 2014 concerning the difficulty of obtaining testimony concerning allegations of sexual violence. And he has invited the Chamber to consider that such evidence exists, even if it's not been referred to in application forms. That is, he has invited the Chamber to base its decision on information and evidence that's not in the court record. And we also know that after receiving these observations, the pretrial chamber then decided to request the prosecution to address several points concerning P570 and P47, the victims of the FADH complaint. And these questions appear to have the objective of inviting the prosecution to expand the charges to conform with the suggestions of Metro Dumbia. And the questions formulated by the pretrial chamber, in particular questions 2 to 10, mirror many of the sentiments expressed by Judge Alapini Gansu in her former role as concerns the experience of female victims of sexual violence and forced marriage in Timbuktu. The fact that these questions have now been issued by the chamber as a whole also creates an appearance that the bench as a whole lacks impartiality as concerns the charges in this case. In terms of the remedy requested by the defence, Article 41, paragraph A specifies that a judge may request the presidency to excuse themselves from exercising functions in a particular case. This was the path followed by Judge Monaghan. The appeals chamber has also ruled that whenever the statute vests the judges with a particular power, the parties have an implicit right to move the judges to exercise that power. And that's the appeals chamber decision on extraordinary review in the DRC situation, paragraph 20. It follows, therefore, that the defence must have an implicit right to move this chamber to consider requesting the presidency to excuse the bench from exercising its functions in this case. Or alternatively, we would request that the confirmation proceedings be temporarily suspended so that we can put the issue before the plenary. Now, the defence has amply demonstrated through the filing of its 100-page brief with 8 detailed annexes that it is ready for this hearing. This is not a delaying tactic. Rather, it's axiomatic, and it should be obvious that such fundamental issues of impartiality must be ruled upon before the substantive component of the hearing can proceed. A criminal process, it's not like a glass of milk. You can't have a trial that's half fair or half not. If the defence is correct, and the 43 questions formulated by the bench have in any way been influenced and impacted by Judge Alapini Gansu's prior involvement in the factual foundation of this case, then the confirmation process as a whole would be tainted if it would be allowed to proceed. The replacement of the bench at this juncture would also not in itself create a delay, particularly bearing in mind the limited function and purpose of the confirmation hearing. Article 61, subsection 7 of the statute specifies that the chamber should reach its decision as to whether to confirm the charges on the matters discussed during the hearing. There's therefore no need for the bench to be appointed prior to the confirmation hearing itself. And in terms of precedent, in the Bemba case, the initial confirmation hearing was conducted before Judge Diarra, Judge Call, and Judge Trentafilova. Judge Diarra's mandate expired at the end of 2008. The presidency therefore appointed Judge Tafusa to replace her, and he was part of the bench that issued the ultimate decision, even though he had not been present during the initial point. We respectfully submit that given the number of judges at the ICC, it should be possible to compose a bench where there's no appearance of issues. Such a step would ensure the integrity of the proceedings and the appearance of justice, which is of equal importance to everyone in this courtroom. And finally, in case there is any suggestion that the defence could and should have raised such issues earlier, my co-counsel, Madame Proul, will address the bench on a discrete issue which explains why there was no effective defence preparation in this case for almost the entire duration of the pre-confirmation proceedings. Thank you very much.
Merci beaucoup. Madame.
Thank you very much, Ms. Taylor. Madame Proul, you have the floor.
Messieurs, Madame les juges, merci.
Thank you, Your Honours. Following the submissions of lead counsel in relation to the preliminary phase and all matters pertaining to this phase, I would like to touch on a procedural issue that was raised by the prosecutor's office in July 2018 regarding the relations between Mr. Hassan and his former lead counsel. The 18 filings on this issue are confidential, so we will not enter into the details of those filings, but simply address the important consequences of that situation on defense's preparation. You see, it is because of the prosecutor's determination to raise a question that has no bearing on previous submissions with the apparent aim of intervening in the specific counsel-client relations that has had a bearing on the rights of the defense. Defense has a fundamental right to time and to facilities which can help in preparing its case. Defense should have been able to prepare in a serene atmosphere without interference from the OTP. But what happened is the contrary. It had to mobilize its own resources to ward off 6 objections or 6 filings from the prosecutor's office, which had no bearing on the proceedings. The 6 filings are number 77, 87, 99, 110, 118, and 142. The defense had to submit some 7 filings in response, being filing 78, 99, 87, 109, 112, 137, and 153. This conflict spanned a period of more than 6 months in this preliminary phase. The Chamber issued decision number 96, 106, and 116, as well as decision 231 in relation to this dispute, which settled the matter at the end of that year. And throughout that period, the defense did not know what the status of the lead counsel would be, and this significantly affected the way in which defense prepared for this case. This unfruitful conflict could have been avoided, Your Honors. It would appear to us that it was obvious that the first motion of filing of the OTP in July 2018 was baseless. It is also obvious that it amounted to an unacceptable interference in the client-counsel privy relations. That filing should have simply been rejected because it was frivolous. Furthermore, if the court had exercised appropriate judicial control, that 6-month conflict would have been mitigated in terms of scope and time. The lack of a decision for over 6 months forced defense to continue to use its own resources to ward off repeated attempts by the prosecutor to somehow interfere in the status of the lead counsel. Conclusively, the filing or the last motion of the OTP was found to be baseless. Therefore, time and resources had been spent and wasted to address this issue because they were not used in the preparation of the case as such. When prosecutors started to disclose thousands of pages of evidence, that was the time for the defense to concentrate on the substance of the matter rather than on that conflict. And this is quite unfortunate from our standpoint. And in addition to other points raised by my colleague, this amounted to a violation of the fundamental rights of the accused to have enough time and resources in preparing his defense. At this very crucial stage of confirmation of charges, the defense is therefore seriously concerned about the impartiality that touches on this trial and its rights that are covered under Article 67 of the statute. Thank you. That will be all. Madam Prosecutor, would you like to respond?
Mr. President, Your Honors, the defense has made extensive submissions this afternoon, which the prosecution is not ready. It is last-minute submissions, which are definitely we're not ready to respond to now. We do believe that these submissions could have been made in a filing, but unfortunately it hasn't. However, we would still, Mr. President, like to make comments on make submissions on the procedural aspect. And I would like to call on the senior trial lawyer to make those submissions. Thank you, Mr. President.
Merci beaucoup, Madame Procureure.
Thank you, Madam Prosecutor. Mr. Duterte, you have the floor. Thank you, Mr. President. Good afternoon, Mr. President. Good afternoon, Your Honors. A lot has been raised, and I must confess that all what has been placed before the bench today by the defense, I must confess, does not raise anything significant that the defense was not aware of a long time ago. That is why these all appear to be last-minute submissions or motions that objectively do delay the proceedings and thereby the confirmation of charges hearing. Quite clearly, there are tons and tons of information and problems that have been raised in those submissions, each being complex in nature and requiring some examination following the extended submissions that have been made in that regard. Therefore, there is need for all that to be filed in writing so that we can provide meaningful and timely responses in writing. However, we can make a few general observations and remarks on a number of points. And may I say that these remarks will not be exhaustive. And I'll take the points as they come. That is to address as many of these remarks as I can. When the defense makes submissions about Judge Alipini Ganzu, I think they are simply looking for recusal or disqualification. And obviously, your chamber is not the forum to tackle such a request. I'm sorry. I believe that in those circumstances, therefore, on that important point, we may have to adjourn the proceedings and forward the transcript of these proceedings to the plenary of judges with a request for the matter to be dealt with urgently. At that time, we will be in a position to make our own written submissions as well. Turning now to some of the points raised by the defense, which need to be clarified, and allow me to say that we will also make more specific submissions in writing, particularly when dealing with assertions that were made in rather general terms. When it comes to our duty to investigate inculpatory and exculpatory material, we did so with our eyes wide open, without excluding anything, and disclosing all necessary evidence which would be useful to the defense. We heard several witnesses of all walks of life, all types of victims, insiders, and what have you. And that enabled us to have a view, a global view of the situation. So we used an open-ended approach with each of our witnesses. We also raised follow-up questions in order to be able to cover all the bases. Now, witness 612 was heard, interviewed, and after obtaining the information that he provided for us, and mindful of our duty to investigate exculpatory material, and by the way, must I say that the defense contacted this witness without respecting the protocol of such contacts as laid down by the chamber. So it would be incorrect to say that we did not do our job properly and that we therefore failed somehow. That was not the case. It is true that there are a few items of exculpatory material, exclusively exculpatory material, but we had requested of defense some specific guidelines or some indications, but we did not get any response. Pursuant to Rule 77, we disclosed a number of documents, including exculpatory material. We also disclosed witness interviews, which also include all types of information, mostly incriminatory, but also Article 77 information that could be exculpatory. And it is up to the defense, based on its strategy, to determine which evidence falls under what category. What I'm saying, therefore, is that we respected our Article 74 obligations and our disclosure obligations. Turning now to interviews with the suspect, Mr. Hassan, I must say clearly and loudly that Mr. Hassan was arrested by the Operation Serval forces and handed over to or transferred to the Malian forces. And we were not involved in that arrest and surrender. We only found out about that in the newspapers, like everyone else. When it comes to allegations about what he claims to have suffered during his detention by the Malian authorities, let me also say that we were not involved and we have no specific stance on that matter as to how he was treated. Let me further say that this does not have any impact on the substance of his interviews. His rights were scrupulously respected, the right to a lawyer, the right not to self-incriminate. All of these were read out to him and repeated to him over and over again. And we noted that Mr. Hassan was so conversant with the rules that at some point he would say, I would rather be silent on this point or on that point because I'm aware of the rules. So, as a matter of fact, most of the things that he told the OTP simply corroborated material that was placed before him, documents that he had signed, and footage or material speaking or dealing with him. So it was mainly a matter of corroboration. Now, reference was also made by the defense to disclosure issues. Now, when the prosecution makes a number of requests under Article 78, it is because of the desire to protect witnesses, and it is for the chamber to make a determination. Therefore, we did what we had to do when it comes to protecting witnesses. The defense further alleges that we failed to disclose useful evidence. It is true that defense submitted a very general request, which could be referred to as a fishing expedition, a drag net that would capture anything whatsoever. And I think that it is for the defense to refer any matter to the bench as it deemed fit. We responded by email, and it was up to the defense to raise any matters with the chamber regarding our responses to very broadly phrased requests. What we have done is deal with what appeared to be relevant to our mind when it comes to those requests from the defense. And I believe that the chamber knows what I'm talking about when I make reference to the recent Rule 77 disclosures, particularly at paragraphs 26 and 27 of the filing. Now, the defense has also referred to that list of 43 questions, and I don't know whether it is for the prosecutor to pry into the hearts of the bench, but I think that the requests from defense are rather speculative, and sorry, Mr. Duterte, I must interrupt you. We have now come to the end of this first session of the confirmation of charges hearing. We will break now and we resume at 4 p.m. and then you can continue. Mr. Duterte, Mr. President, I have only a few more minutes. I need to say one or two things and that will be it. Can I continue? The presiding judge, yes, please proceed. Mr. Duterte, thank you, Your Honor. I think that the parameters are clear. We are not going to submit any new evidence based on the questions that have been raised. There is a list of evidentiary material. The charges before this chamber are clear when it comes to victims and dates and what have you. So I think there is no opportunity here for the prosecutor to expand anything whatsoever. And I think that this point must be made very clear and very clearly. We will answer whatever questions come from the bench, but there is no intent to increase the number of charges nor the volume of evidence. Now, when it comes to the prejudice raised in Madame Pru's question, it would appear to me that it is not a very clearly stated prejudice as such. There is a new defense team in place. It has been in place for a while. There has never been any request for extension of time for purposes of preparation. And once again, we are faced with a last-minute request from defense. And therefore, I must say that I do not see the prejudice that this causes to the defense team. Mr. President, that will be all, Your Honors. Those will be all the brief remarks I wanted to make at this juncture in very general terms. And I therefore hope that what might have to be done is to adjourn and deal with this issue of disqualification by submitting it to the plenary. And then the other issues will be addressed when defense makes its written submissions and we make our own written responses to all these issues once they are clearly submitted. Thank you. Thank you very much, Mr. Dutet. We have now come to the end of the first part of this session, and it is necessary for us to now break so that judges may confer. We adjourn and resume at 4 p.m. Thank you.